Hi, I'm John Dearie, and we're delighted that you're viewing our face-to-face attorneys interviews where we talk about topics that our law firm practices. And today's topic has to do with construction site accidents. And I might say before we get started, I want to highlight the fact that we have free brochures in both English and Spanish dealing with the topic of construction site accidents. And we'd be delighted to send them along to you. They're in question and answer format. They're very much layman's language. And we have found over the years, as we've distributed thousands of these to potential clients that they found it quite interesting. So just make sure and just give us a call or contact us, and we'd be delighted to send it along. To discuss our topic of construction site accidents, attorney John Patrick Dearie. John, again, welcome.
Thank you.
When someone talks about over the years, and have asked us this question so many times, but it's really key, what is the distinction between a construction site accident where an individual is injured in a construction site and workers' compensation? How do those two legal kind of claims go together?
Well, if someone is injured in a construction site accident, they likely have a workers' compensation claim. Workers' compensation claim is a claim to their employer's workers' compensation insurance carrier. Under New York state law, injured workers, injured employees who are injured during the course of their employment are barred from suing in a third-party personal injury litigation action their employer. So if someone is injured while in the course of their employment, they likely will have a claim, again, to their employer's workers' compensation carrier. If the cause of the injured worker's injuries are due to the fault or negligence of some third-party entity that is not the employee's employer, whether that's a general contractor or some other subcontractor or company who caused the defect or condition that was the basis of the worker's injuries, the injured worker, in addition to that workers' compensation claim to their employer's insurance carrier, they may also have a viable third-party lawsuit against the company or person who is not their employer, who was responsible for the condition that caused their accident and injury.
Since we work closely together on construction site accidents and I have some familiarity, I just want to use an example, a couple of examples of exactly what you're talking about. For instance, if a worker is in a shanty, a plumber, and he's on his way to the job site, and there is a delivery of, let's say, pipes, for argument's sake, by another contractor, not his employer, and those pipes fall off the truck and fracture his ankle, for example, that's a classic situation where he has, as almost always, a workers' compensation claim available. And in that particular case, since the truck that was delivering the pipe is a contractor other than an employee, other than his own employer, that would be a third-party case. Two other things that come to mind: often you have a situation where a construction worker trips over a tool bucket that may be left on a walkway, but the bucket was from another subcontractor and this individual trips over it. In that case, workers' compensation plus a third-party case. One other that I can think of, and there are so many of them, another employee from another employer drops a brick, for argument's sake, and hits the person in the shoulder 2 floors below. There again, you have a situation, definitely workers' compensation and also a third-party case. But I do believe in almost any of these areas, if there's one that really requires an attorney that understands the distinction and can find a potential third-party case, if it does exist on the facts, I think that distinction between the third party and workers' compensation really requires an attorney with experience to do it.
Yeah, absolutely. Identifying who viable potential defendants may be for a third party action requires the knowledge and experience of what the law says and what the courts have held constitute viable third party action. So whether it is against some other company, some other contractor working on the same job site, or the general contractor if the injured worker is employed by a subcontractor. In that case, obviously, the worker would not be able to sue his employer, the subcontractor, but there may still be a viable claim against the general contractor, or if there was another subcontractor involved in creating the condition, as you just explained. Yes, understanding who potential defendants may be that would represent a viable defendant in a successful personal injury action, yes, that requires the legal experience and expertise.
You mentioned before the notion that an injured employee cannot sue his or her employer. Why is that?
Well, in New York State, passed several decades ago the workers' compensation law, and the theory or the reason behind the state legislature's goals of passing the workers' compensation law, which bars employees from suing their employer, was kind of a trade-off. It required all employers to pay for and obtain workers' compensation insurance that would guarantee medical coverage and a percentage of an injured employee's lost earnings in the event that that worker was injured during the course of their employment. So it guaranteed to all workers that if you're injured on the job, regardless of whose fault it was that you were injured, even if it was your own fault or a coworker's fault, that injured worker is guaranteed payment for his medical bills and payment for the money that he loses if he cannot work for a period of time after sustaining the injuries. So it guaranteed workers that benefit, and in exchange for requiring employers to pay for workers' compensation insurance, which is obviously an expense to the employer, it protected employers in the form of preventing employees from having the legal right to sue their employer for any injury that they sustain during the course of their employment.
Are there some specific New York State statutes that apply to construction site accidents?
Yeah, the main New York State statute that comes into play in typical construction site accidents would be the New York State labor law. Specifically, 3 sections within the labor law usually come into play. That would be labor law section 200, section 240 sub 1, and section 241 sub 6. So those are 3 of the main statutes that are cited with respect to having been violated when it comes to typical construction site accidents. The other statute that comes into play is the New York State Industrial Code. And the New York State Industrial Code provides several rules with respect to maintaining a safe construction site and safe work area. And what the law says is that if particular sections of the New York State Industrial Code can be shown to have been violated with respect to a condition on a work site that led to a worker's injury, the violation of particular industrial code statutes triggers the violation of one of those 3 sections of the New York State labor law, specifically section 241 sub 6.
Occasionally we hear a horrific accident where an individual falls in the process of construction, falls from the 20th floor to his or her death, a horrible situation. But the issue generally with regard to construction site accidents, height, falling, any type of fall, how does that work and why is that so particularly addressed in terms of statutes?
That goes to one of those three labor law sections, Section 240 sub 1. Section 240 sub 1 of the New York State labor law addresses gravity-related accidents and injuries that result therefrom. So essentially what Section 240 sub 1 says is that if someone is injured as a result of them, the injured worker, falling from a height or something falling from a height onto and injuring a worker on a construction site, that constitutes a violation of Section 240 sub 1. And Section 240 sub 1 is what is called a strict liability law, a strict liability statute, meaning that if an injured worker, if a worker on a construction site is injured as a result of falling from a height or as a result of something falling from a height striking the worker and injuring him, the general contractor or the owner of that premises, of that property, is automatically considered negligent and liable for having violated Section 240 sub 1 of the labor law unless it can be shown that the accident was caused entirely as a result of the actions and negligence of the injured worker themselves. But so long as the evidence shows that the worker was not completely 100% responsible for having been injured as a result of falling or something falling onto him, then most likely the general contractor or the owner of that property will be considered negligent for having for a violation of Section 240.
Something that's important in any kind of litigation of an accident is the so-called statute of limitations. So let's address what is the statute of limitations, and particularly for construction site cases.
The statute of limitations to file a third-party lawsuit, that would be any type of lawsuit other that is not against the injured worker's employer. The statute of limitations for that type of third-party action is 3 years from the date of the accident. That is different than the particular statutes of limitations for commencing a claim to workers' compensation, a workers' compensation claim, which is shorter than that. But with respect to third-party actions against non-employer entities, the statute of limitation is 3 years.
Now, in many of these construction sites, they are being funded by a governmental agency. Could be the state, could be the city, could be the MTA, whatever the case may be. So long as we're talking about statute of limitations, there are shorter time periods, aren't there, than that 3 years?
Yes, if the defendant is a municipality, whether it's the City of New York or a City of New York agency or a State of New York agency, there are shorter statute of limitations, anywhere from 90 days to file what's called a notice of claim to alert and notify the municipality that an eventual lawsuit may follow. So anywhere from 90 days to a year and 90 days. So it is very important that if someone is injured during the course of their employment on a construction site, and particularly if the possibility exists that a potential defendant is a municipality, a city or state entity or agency, that the injured person contacts and speaks to us as soon as possible, because there are those shorter statute of limitations when a municipality is potentially involved.
A person that's been injured in some kind of a construction site accident, and you're available obviously for a free consultation, what are the 2 or 3 key questions that you're going to ask a potential injured individual, irrespective of what their job may have been or how the accident may have occurred? What are you asking them, and what should maybe thinking about in preparation to talk with an attorney?
Well, first of all, what happened factually? How did this accident happen that caused you to be injured? what your medical treatment has been from the date of the accident, if you have been yet diagnosed with any medical conditions, whether it's a fracture or a tear of a ligament or tissue or any type of spinal condition. So what the medical treatment is, the facts of how the accident happened, and then also to the extent that the injured worker may know, who his employer was, who the general contractor was, who was the owner of the premises, any other subcontractors who were working on the construction site, names of any witnesses, things like that.
How would you classify sort of the major categories of injuries that you've seen resulting from construction site accidents?
Oftentimes, if someone falls from a height, it is possible that they suffer a fracture to a bone, whether a fractured ankle, fractured leg, fractured arm, wrist, something like that. Alternatively, there are many cases in which the injured worker did not suffer a fracture, but may have suffered injuries along the lines of a torn rotator cuff in the worker's shoulder, some type of torn meniscus in the worker's knee, a bulged or herniated disc in the worker's spine, things like that.
Someone gets an award, has an injury, goes through a lawsuit. What's the time period, basically, would you say, again, from the time a person calls, appears to have been injured, and the ultimate resolution, whether it's a settlement or a verdict? What, roughly speaking, should a person be anticipating in time?
When it comes to construction site cases, those can be more complex, and the discovery process can be longer than in other types of personal injury actions. That oftentimes is the result of because the injured worker cannot sue their employer and the action is brought against the general contractor or another subcontractor or the owner of the premises, that defendant oftentimes may sue and commence an action in what's called a third-party action against the injured worker's employer. But for various reasons, because there are many parties that work on construction sites and are potentially involved, construction site cases do tend to take longer than other types of personal injury litigations. But in terms of timing, it could be anywhere from 3 years to 5 years to 7 years to potentially more than that from the point in time, of course, depending on the complexity of the case, from when the accident happens until when the case is ultimately brought to a conclusion.
Let's end by highlighting how a person could get in touch with you should they feel that they've had an accident and wanted to consult with an attorney, emphasizing that it's a free consultation.
Anyone can contact me anytime. My phone number at the office is 212-980-0404, and my email address is jpd@johndearie.com.
Thanks very much. Hope you've enjoyed our discussion with regard to a very important topic within our area of practice, namely the construction site accidents. Thanks very much.